The day they buried my mother, my Uncle Marcus handed me a folded piece of notebook paper and said, "She wanted you to have this." I opened it right there in the parking lot of Riverside Memorial, rain coming down soft and sideways, and read 4 words in her handwriting. "Don't sign anything yet." I didn't know what that meant. I was 31 years old, standing in a cemetery in Dayton, Ohio, wearing a tie she had bought me for my college graduation 9 years earlier. I folded the paper back into thirds and put it in my jacket pocket, and I thought maybe grief makes people cryptic at the end. Maybe it meant nothing. Maybe she had been confused. She had not been confused. Her name was Carol Mercer. She was 58 years old when the pancreatic cancer took her, which means she was 29 when she had me, which means she spent exactly as many years raising me as she spent alive without me. I've thought about that math more times than I can count. She worked for 22 years as a paralegal at Dunmore and Fitch in downtown Dayton. She knew how documents worked. She knew what signatures meant. She knew things that people who have never sat inside a law office for 2 decades simply do not know. My father, Raymond Mercer, left when I was 4. I don't say that for sympathy. I say it because it explains the geography of my family, which is the geography of a wound. When he left, his side of the family, the Mercers, closed ranks around him and decided collectively that my mother had driven him out. His sister Patricia, my Aunt Pat, became the loudest voice in that particular fiction. She told it at every holiday, at every gathering, to every cousin who would listen, for 27 years. I grew up going to those gatherings anyway because my grandmother, Evelyn Mercer, was there, and she was the one person on that side who had never once looked at me like I was an inconvenience. She was small, white-haired, sharp-eyed, and she made a peach cobbler every Sunday that I would drive 40 minutes for without complaint. She had lived alone in the house on Sycamore Street, in Kettering, since my grandfather died in 2009. 4 bedrooms, a finished basement, a backyard with a stone bird bath. She had placed herself in 1987. The house was worth, as of last year's appraisal, $340,000. Grandma Evelyn died in January. 6 weeks after my mother. 2 funerals in 6 weeks is a specific kind of exhaustion that I don't have the language for yet. I drove to Kettering for Evelyn's service in the same tie, which I had dry cleaned between funerals because it was the only good one I owned. My Aunt Patricia was at the door of the funeral home when I arrived. She was 61, hair dyed the colour of a new penny, wearing a black dress with silver buttons that were slightly too formal for a Tuesday morning in January. She had the look of a woman who had already started mentally rearranging the furniture. She hugged me. It lasted exactly long enough to feel performative. "Your grandmother loved you so much," she said. I nodded. I said thank you. I went inside. The service was quiet. Evelyn had outlived most of her friends. The pastor read from Psalms. My cousin Derek, Pat's oldest, read a poem he had printed from a website. I could tell because the font was slightly different from the paper and the margins were wrong. My father Raymond sat in the front row in a grey suit and did not turn around once to acknowledge that I was 3 rows behind him. I had not spoken to my father in 11 years, not since he missed my college graduation to attend Derek's rec league baseball tournament in Cincinnati, and did not call to apologise. After the service, Patricia pulled me aside near the coat rack. She had a manila folder in her hand. "We need to talk about the house," she said. I said, "Okay. Your grandmother left a will. She left the house to the family, which your father and I have been discussing, and we think the cleanest thing is to sell it and split the proceeds between the direct children. That's your father and myself." I said, "What about me?" She smiled the smile of someone who has rehearsed this smile. "Honey, you're a grandchild. The estate goes to the children first. That's just how it works." I did not know enough then to say what I know now. I just stood there in my dry-cleaned tie and nodded and said I understood, and walked out to my car and sat for a long time in the parking lot before I drove home. It was on the drive home that I remembered the note. "Don't sign anything yet." My mother had been a paralegal for 22 years. She had worked on estate cases. She had helped draft wills, trusts, probate filings, inheritance disputes. She had sat in rooms where families tore each other apart over dining room tables and certificate of deposit accounts. And 6 weeks before Patricia told me the estate goes to the children, my mother had pressed a folded piece of notebook paper into Marcus's hand and told him to give it to me at her funeral. She had known. She had known something was coming, and she had known I wouldn't know how to see it. I pulled over on Route 35 and I called Marcus. He picked up on the second ring. I asked him when my mother had given him the note. He said 3 days before she died, when she was still lucid and could still hold a pen. He said she had also given him something else, a sealed envelope with my name on it, that she had told him to hold for 30 days before he gave it to me because she didn't want me distracted during the grief. 30 days, I said. That's what she said. It's been 38. I turned around and drove to Marcus's apartment in Huber Heights. He handed me the envelope over the kitchen counter. It was standard letter size, sealed with tape over the flap, my name written in her handwriting. Inside was a 4-page letter and a business card. The business card said, Sandra Okafor, Esquire Estate and Probate Law, Okafor Legal Group, Dayton, Ohio. The letter started like this. Daniel, if you're reading this, I've been gone long enough that you can hear me clearly. There are things about your grandmother's estate that Patricia does not want you to know, and I found out about them 8 months ago when Evelyn called me crying. I sat down on Marcus's couch and I read all 4 pages without stopping. My grandmother Evelyn had drafted a will in 2019. In that will, the house on Sycamore Street was left in 3 equal parts. 1/3 to Raymond, 1/3 to Patricia, 1/3 to me. She had done it specifically because she had watched Patricia's behaviour at family gatherings for 20 years, and she had told my mother on the phone, I will not let that woman take what belongs to Daniel. In October of last year, 3 months before Evelyn died, Patricia had hired an attorney in Miamisburg to draft a new will. She had brought the attorney to the house on a Sunday afternoon, when Evelyn was having a bad week with her hip. She had told Evelyn it was just an update, just routine, that the 2019 document had a clerical error that needed correcting. Evelyn had signed it. She was 83 years old, with a bad hip on a bad Sunday, and she trusted her daughter and she signed it. The new will left the house entirely to Raymond and Patricia, split equally. My name was not in it. My mother had found out because Evelyn had called her 2 weeks after signing, confused, asking if she remembered signing something because she didn't quite recall what it had said. My mother had driven to Kettering the next day and had read the new will while Evelyn napped. She had photographed every page on her phone. She had then called Sandra Okafor, who she had worked alongside on estate cases for a decade, and described what she saw. Sandra Okafor had told her that in Ohio, a will executed under circumstances involving misrepresentation of the document's contents was potentially voidable under undue influence. She had told her that Evelyn's 2019 will would stand if the 2021 document could be challenged. She had told her that the key was documentation and that timing was everything. My mother had spent the last 8 months of her life while managing her own cancer treatment, building a file. She had written down the date and time of Evelyn's phone call. She had photographed the 2021 will. She had written a 3-page statement, signed and dated, describing every detail of what Evelyn had told her. She had arranged for Sandra Okafor to hold a copy in trust, and she had given Marcus a note and an envelope and a 30-day instruction because she knew she might not last long enough to hand them to me herself. I called Sandra Okafor the next morning at 8:02. She answered before the second ring. I've been waiting for your call, she said. Your mother told me you'd reach out when you were ready. We met at her office on Wayne Avenue 2 days later. She was 47, direct, with a yellow legal pad that she wrote on in small, precise letters. She had my mother's statement in a manila folder. She had the photographs of both wills. She had already pulled the probate filing Patricia had submitted to the Montgomery County Probate Court the week after Evelyn's funeral, the one based on the 2021 document, the one with my name absent. She set both wills side by side on the desk. The 2021 document was signed by your grandmother in the presence of one witness and a notary hired by Patricia's attorney. The 2019 document had 2 independent witnesses. Under Ohio law, both are technically valid on their face. The question is, which one reflects your grandmother's actual intent? I asked her what we needed. She tapped my mother's statement. This is significant. Your grandmother told Carol that she didn't fully understand what she was signing. That's a statement against interest from a woman with 22 years of paralegal experience who had no financial stake in the outcome. It's not testimony because she's gone, but it's a sworn statement and it's admissible as documentary evidence. She paused. There's something else. Your mother also noted in her statement that your grandmother made one comment during that visit that your mother wrote down verbatim and highlighted. She slid the page across the desk and pointed to a yellow highlighted line near the bottom. Evelyn said, and I am quoting her directly, "Patricia told me the new paper was just fixing Daniel's share so it wouldn't cause problems with taxes. I thought I was helping him." Sandra looked at me over the legal pad. Your grandmother thought she was signing something that protected your share, not eliminated it. I sat with that for a moment. Evelyn had been 83 with a bad hip on a bad Sunday, and she had signed a document designed to take from me while believing she was signing something that helped me. I asked Sandra what the timeline looked like. Patricia's probate filing gave us 90 days to contest. We have 44 days left. Patricia did not know any of this existed. She did not know about my mother's statement. She did not know about the photographs. She did not know that the woman she had dismissed as Raymond's difficult ex-wife had spent her last coherent months constructing a legal record from a hospital bed in Dayton, Ohio. She found out on a Thursday morning when Sandra filed the formal contestation with the Montgomery County Probate Court. I know she found out that morning because she called me at 11:47 that same day. I let it go to voicemail. She did not leave one. She called back at 12:03, and I let that go too. At 12:31, she called from Derek's number, which I also did not answer. At 1:15, my father called from a number I didn't recognise, which told me they were all in the same room, and he had been listening the whole time. He left a voicemail. I played it once. He said, "Daniel, I don't know what you think you're doing, but this is family business, and you need to call me back before you make a mistake you can't take back." I had not heard my father's voice in 11 years. He sounded older. He sounded rattled. He sounded like a man who had just been told that the thing he thought was finished was not finished. I did not call back. The hearing was set for March 14th in courtroom 4 of the Montgomery County Probate Court on West 3rd Street. Sandra spent the 6 weeks between filing and hearing date building the case. She deposed Patricia. She obtained phone records that showed 14 calls between Patricia and her attorney in the 2 weeks before Evelyn signed the 2021 document. She obtained the attending physician's notes from Evelyn's October appointment, which described her cognitive state as alert and oriented, but noted significant anxiety and a tendency toward compliance to reduce conflict. That phrase, tendency toward compliance to reduce conflict, had been written by a doctor who had no idea it would one day matter this much. Sandra also found something she had not initially expected to find. The attorney Patricia had hired in Miamisburg, a man named Gerald Foss, had prepared the 2021 will. When Sandra pulled his disciplinary history from the Ohio Supreme Court Attorney Registry, she found a 2017 informal admonition for failing to independently verify client instructions in an estate matter. It was not disqualifying, but it was a pattern. It was the kind of detail that makes a judge look up from her papers and look at the attorney in a different way. 3 days before the hearing, my father called again from his own number this time. I picked up. The silence lasted almost 4 seconds. "This is tearing the family apart," he said. I said, "Dad, you didn't call me when you missed my graduation. You didn't call me when Mum got sick. You've called me twice in 11 years, and both times were because something you wanted was in jeopardy. I don't think I'm the one tearing anything apart." He said, "Your grandmother would not have wanted this." I said, "Grandma Evelyn called Mum crying because she thought she'd been tricked into taking my name off her will. She's the one who set this in motion. I'm just honouring what she asked for." Another silence. "I didn't know about the 2019 will," he said. And the way he said it, the way the sentence landed flat and slightly too quiet, I knew it was true. Patricia had not told him. She had handled it herself and told Raymond after the fact. And Raymond, who had been agreeing with the loudest voice in the room for his entire adult life, had gone along. I said, "Come to the hearing on Thursday." He didn't answer. I heard him breathing. "Come to the hearing," I said again. "See what actually happened." I hung up. The morning of March 14th was cold and clear, the kind of Ohio morning that looks warm through a window and isn't. I arrived at the courthouse at 8:40, in a dark blue jacket my mother had given me 2 Christmases ago. Sandra met me outside the security entrance. She had a rolling briefcase and a calm that I was grateful for. Patricia and Derek were already in the hallway outside courtroom 4 when we got there. Foss was with them, the Miamisburg attorney. shorter than I expected, with a suit that was slightly too large in the shoulders. Patricia looked at me when we came around the corner, and her expression did exactly what I expected. A rapid sequence of contempt, recalculation, and something that might have been fear if she allowed herself that. Derek looked at his phone. My father was sitting on the bench by the water fountain. He had come. He was wearing a suit I did not recognise, and his hair was greyer than I remembered, and he was sitting with his hands on his knees in the posture of a man who has decided to be present for something he does not fully understand yet. He looked up when I walked past. He did not speak. I did not speak. I nodded once and went through the courtroom door. Judge Anita Caldwell had been on the Montgomery County probate bench for 16 years. She was 59, efficient with reading glasses she took on, and off depending on what she was looking at. She did not perform authority. She simply had it. Foss opened for Patricia. He argued that the 2021 will was validly executed, witnessed and notarized, and that the 2019 document had been superseded. He argued that Evelyn had been of sound mind and that the change in distribution was her explicit wish. He used the phrase family realignment, which Sandra later told me she had never heard in 19 years of estate law. Sandra did not object to any of it. When it was her turn, she stood up and she submitted my mother's sworn statement. She submitted the highlighted line. She submitted the physician's notes with the phrase tendency toward compliance to reduce conflict. She submitted the phone records showing 14 calls between Patricia and Foss before the signing. She submitted Foss's 2017 disciplinary record. She did not editorialize. She described each document in 1 or 2 sentences and set it on the record. Then she called one witness, Marcus. My uncle Marcus, who had driven from Huber Heights in his good coat and sat in the witness chair with the composure of a man who had loved my mother for 30 years and was doing the last thing she had asked him to do. Sandra asked him one question. Mr. Mercer, please describe the condition and communication ability of Carol Mercer in the days before she passed. Marcus said, she was clear, sharp as she'd ever been. She knew exactly what she was saying and why she wasn't confused. She was careful. She was making sure Daniel would be okay after she was gone. Foss cross-examined. He asked Marcus if he was aware that Carol Mercer had no legal standing in the estate of Evelyn Mercer. Marcus said yes. Foss asked if he was aware her statement was therefore merely personal testimony. Marcus said, she was a paralegal for 22 years. She knew the difference between testimony and a sworn statement. She wrote it down because she knew I wouldn't be enough on my own. She did my job for me before she died. There was no sound in the courtroom for a moment after that. Judge Caldwell recessed for 18 minutes. When she came back, her ruling was delivered in the even tone of someone who had made up her mind before she left the room. The court finds that the 2021 document was executed under circumstances consistent with misrepresentation of its contents to the testator. The testator's own statement to Carol Mercer, documented contemporaneously, indicates she believed she was signing a document that protected the interests of Daniel Mercer, not one that eliminated them. This court does not find that Evelyn Mercer intended to disinherit her grandson. The 2019 will is reinstated as the operative document. The estate shall be distributed accordingly. She looked up. The court also notes for the record that the preparation of a will, under circumstances where the testator is misled about its contents, constitutes a matter of potential professional concern. This ruling will be forwarded to the Ohio Supreme Court Office of Disciplinary Counsel for review of Counsel Gerald Foss's conduct. Patricia stood up so fast her chair slid back. She said, Your Honour, this is not... Foss put his hand on her arm. She stopped. The judge had already moved to the next file. In the hallway, Sandra squeezed my shoulder and went to gather her papers. Derek walked past me without making eye contact. Patricia stood near the elevator, and I watched her face do the work of someone rearranging a story they had been telling themselves for a long time. She looked older than she had that morning. She looked like a woman standing in the rubble of a plan she had been certain was finished. My father was still on the bench by the water fountain. He was still sitting with his hands on his knees. He looked up when I came through the door. He had been in that hallway the whole time, and I don't know when he moved from the bench to just inside the courtroom door, but he had heard everything. He said, She did all that while she was sick. I said, Yeah. He looked down at his hands. I should have known Pat had done something. I should have asked questions. I did not tell him he should have. I also did not tell him he was forgiven, because he wasn't. Not yet. And I wasn't going to lie about it, just because the room called for something softer. What I said was the truth of where I actually was. She left me a note that said, "Don't sign anything." I didn't know what she meant for 6 weeks. He nodded. His jaw moved. "She was trying to protect you even then," he said. Not to me exactly. More like he was saying it to himself, to something he needed to confirm out loud. I said, "She always was." He stood up. He didn't hug me. He didn't ask for anything. He held out his hand and I shook it. The way you shake the hand of someone you are deciding whether to know again. And he walked to the elevator, and the door closed, and I stood in the hallway of the Montgomery County Probate Court, with Sandra's card in my pocket, and my mother's voice, somewhere in the back of my chest, saying, "Don't sign anything yet." I didn't sell the house. I know that surprises people when I tell them. $340,000 is not money you turn down when you're 31, and you've been living in a 2-bedroom in Dayton with a second-hand couch. But I'd spent enough time in that house to know what it held. The stone bird bath Evelyn placed herself in 1987. The peach cobbler on Sundays. The way the kitchen smelled like cedar and dish soap. My grandmother had wanted me to have a third of that. My mother had fought from a hospital bed to make sure I did. I'm living there now. I moved in April. The third step on the back porch creaks and I've decided not to fix it. There is a drawer in the kitchen where I keep 2 things. My mother's 4-page letter and my grandmother's 2019 will, the one that had my name in it the whole time. Evelyn had written it in 2019. She had put my name in it in 2019, before Patricia's plan, before Gerald Foss and his too large suit, before any of it. She had done it quietly without telling anyone because she knew the family well enough to know that saying it out loud would have started the war earlier. She had protected it by keeping it secret. And she had protected me by keeping faith with it, even when someone sat down beside her on a bad Sunday and put a pen in her hand. My mother had kept faith with it too, all the way to the end. I keep both documents in the same drawer because they belong together. They are the same sentence written in 2 different hands. They say the same thing. "We saw you. We made sure. The last time I was at the cemetery, I brought daisies for my mother's grave, which is something I'd never done before. And I stood there longer than I meant to, because I kept thinking about her sitting in that hospital room, writing 4 pages by hand, while managing a cancer that would kill her in 8 months. Making sure the envelope got to Marcus. Making sure Marcus knew to wait 30 days. Making sure Sandra Okafor had a copy of everything. Making sure every single door was open before she walked through the last one. She had been a paralegal, not a lawyer. She had no official standing. She had no authority. She had only the knowledge of 22 years, and the love of a mother who knew her son didn't know enough yet to protect himself. And she had built something with those 2 things that a courtroom in Dayton had to honour. I don't know if that's justice. I know that's what she had instead of time, and she made it count more than most people make a lifetime. The note is still in my jacket pocket. I never took it out. I've had the jacket dry cleaned twice since she died, and both times I took the note out first and held it until it came back. 4 words. Her handwriting. "Don't sign anything yet." She wasn't talking about a will. She was talking about the rest of my life.